Sure, I think there is certainly a headline appeal to this story. It's a loss for Google. It's one of the few losses that they've had in courts, one of the few big tech losses. It's not a case brought by the government. There's been a lot of attention to the cases brought by Lena Khan, Jonathan Cantor against big tech companies. This is not like that. This is a private antitrust case brought by Apple that started 3 years ago, or brought by Epic, started 3 years ago. They brought a similar case against Apple, which Epic Games lost. But here, before a jury, not a judge, Epic prevailed. And I think it certainly is a loss for Google, but we'll see how this unfolds, because I think that one of the things about these App Store cases is that fundamentally, they're not particularly about consumers. They're mostly about App Store commissions. And Epic would like to not pay Apple or Google's commissions on App Store transactions, particularly in-app purchases on gaming. And so at the end of the day, we may see that Epic gets to perhaps get more percentage on those transactions, but that's fundamentally what we're talking about here. How much money is going to go to Google and how much money is going to go to Epic for these in-game transactions?
Well, I mean, I guess you could argue at some point that the charges overall for consumers could be better, right? The cost they pay could be better depending on the economics for the individual players. But be that as it may, I think everybody's just trying to figure out what happens now, right? If Google does appeal as it's expected to, then what, right? If this comes before a different judge.
Yeah, great question. So the first step before an appeal will likely be the remedies phase. And so early next year, the same judge will have to determine, given that the jury has found Google guilty, what are appropriate remedies. The judge has already said he is not going to try to micromanage the commission fee that Google charges to app developers. And so, for example, whether or not Epic pays 30% or 29% or 15%, that's not going to be a subject that he's going to decide. But what we may see instead are policy changes. So changes to the rules of how Google runs the Google Play Store, and particularly around in-app billing. One of the things that Google has been rolling out as a pilot program over the last year is alternative in-app billing besides Google Play. So a developer could allow other forms of billing besides Google Play's billing. I think it's very likely that we could see a remedy in this case look something like that, right? Provide Epic and perhaps other gaming services with these basically develop user choice billing options besides Google Play billing.
And Adam, I'm also interested to get your take. What was the difference between this case and the Apple Epic case, in which there Epic mostly lost?
Yeah, well, I think the biggest difference is that this was a jury trial and the last one was a judge trial. So at the end of that trial, we had a 50-page opinion from a judge. At the end of this trial, we have a 8-page questionnaire that the jury filled out. And so, we don't know much about the jury's reasoning. They didn't have to grapple with a lot of those questions. I do think there are differences between the Apple model, which is more of a closed ecosystem, and the Android ecosystem, which is more of an open one. And some of those, I think, might have played into the jury's analysis here. But it's important to say that if Google appeals this decision, it appeals it to the Ninth Circuit, which is the same judge that affirmed Apple's win against Epic in its case. And I think you may see that the Ninth Circuit has to grapple with how these two cases could come to different outcomes, and particularly this question of whether iOS and Android truly compete with each other, because in the Epic case, the jury found that Android does not compete with iOS, but in the Apple case, the judge found that Apple does compete with Android. And so they're going to have to potentially grapple with that on appeal.
And Adam, I want to get you out of here on this, kind of switching gears in this last question. These reports, Adam, that Apple is now offering to let rivals access its tap and go mobile payment systems tech in Europe. I'm just curious to get your take on that, Adam. It looks like, trying to settle these EU antitrust charges there, but how, in your opinion, this would kind of work? Would this be, kind of Apple just goes region by region and would kind of just carve out Europe here?
Well, it's important to say that this is something that hasn't really been pushed for by consumers. It's been pushed for by PayPal and other competing payment services who'd like to be able to access the NFC chip on iPhones and process payments the same way that Apple Pay does. Of course, people have lots of ways to process payments on a phone. They don't have to use the NFC chip. They could do it through QR code. They could do it through other means. But I think this is not terribly surprising given Europe's general direction on tech regulation as part of the Digital Markets Act. They have shown little hesitation to kind of intervene to help a competitor, regardless of whether or not that's beneficial for the consumer. I think we're going to see with a lot of these European actions, there may be some downstream consequences in terms of security and other things that the regulators maybe haven't fully grappled with. But right now, their focus is pretty squarely on, how can we help maybe the competitor who's in front of us who has lodged complaints? And I think that's what's at play here.